morning, and welcome to Talk of the Town on 99.7, 1450 WHTC and WHTC.com.
And we welcome you to Talk of the Town for this Friday, December the 11th. I'm Gary Stevens. We'll be open line following the 10 and 11 o'clock news blocks in about an hour after Patty Vandenberg's What's New Around Holland. We'll get the update from Dumont Lake. That's where the Allegan County administrative offices are, with County Commissioners Jim Story and Dean capping up. But in our first half hour on the second Friday of the month, it is Ask the Attorney, when we have one of our local attorneys answer your legal questions. We, of course, always say that this is only for advising purposes only. If you have a specific problem, you need to speak to your own attorney, but we can sort of give you a little bit of direction along those lines. And it is not so much a criminal activities that we are talking about. It is more probate and business law. And we rotate the two men that join us on a bi-monthly basis. During the odd-numbered months, it is Nathan Box from Central Park Law. But during the even-numbered months, it is Ken Puzycki from the law office of Kenneth A. Puzycki in Holland. That's where he is in our Zoom connection, and he joins us this morning. Ken, good morning, and welcome back to WHTC.
It's good to be back, Gary. You too. You weren't here in October.
Yes, I was not here because of, and I may not be here in February when next time you chat, if we do have high school basketball, because I work in the evenings. And so we let Peg take care of this,
Very cool.
The conversations as well, but via the Zoom connection. But you listening out there, you don't need to go on Zoom. You don't need to even ask for an invite. We will have you call at 395-1450, 395-1450. Again, Ken's specialty is probate, so don't ask him any Supreme Court questions.
No, bring it on. Bring it on.
Okay.
I had my coffee this morning, Gary. Bring it on.
Okay.
Okay. I may not give you the correct answer, but I'm willing to talk about it.
Okay.
Yeah.
Standing to sue. Does Texas have standing to sue in this litigation they have against the state right now? The state on the vote?
Not a chance. No.
Okay.
They have not suffered a loss. They have no legal standing. They should have asked somebody in the state of Michigan to bring the suit for them. But then they wouldn't have had original jurisdiction in the Supreme Court. You see, cases between states have original jurisdiction in the United States Supreme Court. Otherwise, the case has to go through the district court, appellate court process, and that often takes a lot of time. By having state versus state, you get original jurisdiction at the Supreme Court level. So you have to have two states going after each other. The problem there is, as you point out, do they have standing to bring a suit? In order to bring standing, they have to have suffered damage or injury, and I just don't think that they did. Where is the damage suffered by the state of Texas caused by the Commonwealth of Pennsylvania or states of Georgia, Wisconsin, or Michigan? I guess they by virtue of the fact that those four states elected or submitted votes in their electoral college for a different person than the state of Texas. But boy, that is way out there. I just don't think they passed the standing test to begin with, which means they're not going to get to the underlying claims, unfortunately.
Peg McNichol has a question from the WHTC newsroom.
And it's something that one of our Facebook readers brought up. Representative Huizinga, in talking about, in his 9-minute explanation of why he joined this lawsuit, he explained that technically he's being sued by Texas as well because he's a Michigan lawmaker, but he cites the U.S. Constitution, Article 1, Section 2, Clause 2, which I had to go double check. The Annenberg Guide to the U.S. Constitution is my reference for this. And they say that this is a difficult striking point because it has to do with how you count who's allowed to vote. And actually, this section, as explained by Annenberg, it says that it changed, the formula changed after the Civil War and the 13th Amendment. But what Attorney General Dana Nessel is saying that this Texas lawsuit is specifically aimed at disenfranchising voters.
Yeah.
So can you speak to that a little bit and help people understand what that means?
A little bit. And if, well, actually, my constitutional law professor has passed on, so he can't be listening in. But I'll give you my 50-cent version. Each state has the ability under our federalism guidelines to come up with its own way of allocating their electoral votes. For example, in the state of Maine, it's not an all or nothing state, right? The state of Maine says, hey, if half of our constituents vote for Trump and half of those constituents vote for Biden, we can allocate our electoral votes 50-50 based on the popular vote within the state. Michigan is an all or nothing state, as are all other states except Nebraska and Maine. But the point being, each state has the autonomy to determine how to vote for, how to allocate their votes for president of the United States. For example, in Michigan, mail-in ballots cannot be received after the end of the day on election day. In Pennsylvania, they voted, their legislature said, hey, we're going to do it as long as those ballots are postmarked by the end of the day on election day, they're going to be accepted. So there are variations state by state as to how their electoral votes are tabulated, counted, handled, however you want to describe it. Yeah, I don't know if that answers your question, but the reality is that how does the state of Texas have any dog in the fight, so to speak? That is, how does the state of Texas have standing to contest the way that Pennsylvania and Michigan and Georgia and Wisconsin chose their electors? And I just don't think they do. I don't think they do.
395-1450. Good morning. You're on the line with Attorney Ken Puzycki.
Good morning.
Good morning.
I've asked this question before. What are the rules of evidence? It seems like a lot of these cases are just thrown out. Apparently the judges won't even hear them. And I mean, hundreds of people have signed affidavits that they saw this and that. I mean, do you up and say, well, you really didn't see what you saw? I mean, it just doesn't seem right that judges can do something before the evidence is presented. And of course, someone then come up and said, well, you need special election lawyers to present it.
So in order to, and again, there's two levels to your question. It's a very good question. On what grounds do these judges just throw the case out? Well, in order to make it past the first hurdle, if you will, the plaintiff, the one who brings the suit, has to establish a certain threshold of proof. They have to establish prima facie evidence that a wrong has been committed. Now, I'm not privy to what was alleged in any of these lawsuits, and I've not yet read the judge's opinions, but according to the news records of this, the judges have all virtually unanimously said that that the plaintiffs have not presented enough evidence to get over that first hurdle. Now, the second level of your question gets to this case between Texas and Michigan, because in a typical federal case, the case is filed in district court, and the district court looks at the evidence and looks at affidavits, takes deposition testimony, et cetera, et cetera. If that case is filed at the Supreme Court from the get-go, and again, this Texas versus Michigan and Pennsylvania case, the case is not going through the appellate process, it's going directly to the Supreme Court. So now, to your point, now the Supreme Court is supposed to look at the evidence to determine whether or not there's enough to go forward. Usually that is done at the district court level, and then the Supreme Court has to give deference to the district court. But now, if it's filed in the Supreme Court, it's up to the Supreme Court justices to look at the evidence. So the short answer to your question is, it's going to be very interesting to see if the Supreme Court justices do the same thing as the district court justices have done, and that is throw the case out on its ear based on lack of evidence.
But how can they throw it out when in many cases the evidence wasn't even allowed to be presented? No, it was presented. The plaintiff, you really didn't see what you saw.
Well, the evidence was presented, but for example, if an affidavit was based on hearsay testimony, that affidavit can be thrown out. Now, to your point, if I sign an affidavit that says, here is what I saw, then the question becomes, okay, even if what you say you saw actually happened, so what? What is the legal effect of it? Now, I don't know factually what was alleged. I don't know what these affidavits say these people saw, but the judges obviously decided that even if those affidavits were true, they don't amount to enough proof to make it over the first hurdle.
Yeah. Well,
obviously very political.
I'm going to steal something from Hayakawa. Biden and Harris stole the election fair and square.
We'll see. We'll see about that. Appreciate the call, though. Thank you. 395-1450, 395-1450. Off the cuff question, Ken. I think it's going to drive more people to go into law school because they want to get involved with this.
Actually, I think it'll drive people away from law school myself. It's an interesting issue. I think more lawyers might end up gravitating towards election law. And I don't know. I don't know any election lawyers.
Okay. That was the one other question that the caller had is, is there special election lawyers? Just as there are about lawyers for criminals and civil, and probate, which is your specialty.
Adoption lawyers, immigration lawyers, and election law. This is going to generate a very strong demand for attorneys that know election law, because this is going to change the landscape of election law moving forward. And if nothing else that arises out of these lawsuits that have been rejected, states are going to revise all of their election law rules, procedures, and regulations, because that's basically what's being alleged here, is that there were inconsistencies and problems with the process. So at the very least, I think every state, that at least those that are involved here, are going to go back and relook at their election laws, revisit them, maybe modify them, maybe not. I don't know, but something's got to be done with the processes so that this doesn't happen again.
395-1450. Good morning. You're on the line with Attorney Ken Puzycki.
Well, I got a question for Ken.
Hi.
Okay, me and my wife, we don't have any kids.
Okay.
We have a trust. Say we get elderly, we're in our upper 80s, one of us dies. The other one's in assisted living. What kind of outfit or institution controls your affairs and your trust? Because you may be, dementia starting or something, and you want somebody to, like on the old TV shows, Perry Mason or something, we just handle all this stuff. Who handles that stuff for your estate?
Whomever you appoint. Now, you're bringing up a very, very important point, and that is couples who have kids really don't have as big a problem as you do. Because if you've got a married couple and they've got 3, 4, or 5 kids, and mom and dad get dementia, those kids can go to court and get guardianship over mom and dad and take care of business. Okay? For couples that don't have any children, your question is a wonderful one. Who steps in? Now, you have the right through your trust, through your medical power of attorney, through your financial power of attorney, you have the right to choose who that person will be. Okay, so I don't know if you have a niece or a nephew and a confidant at church, but you have the right to choose who that person will be to manage your affairs if you become incapacitated. It's a very, very, very important question. And I don't know if you've read any of the, there've been some articles recently in some of the national magazines that are talking about the problems with court-appointed guardianships, because there are companies out there who will have themselves appointed as the guardians for these people without family members, and they will just run roughshod on the finances. And the point being, it's very, very important that you choose who that person will be, because if you don't choose that person, it's up to the probate court to choose that person for you. And the judge may not appoint the same person that you would have wanted. So you have the ability, you have the legal right to choose who your medical power of attorney will be, who's going to pull the plug on you. You have the right to choose who's going to manage your finances if you're incapacitated. And ultimately, at the end of the day, you have the right to choose who your executor is going to be or who your trustee will be to administer your estate after the two of you are gone. But it's a very, very, very important question.
Well, see, my trustees will be in their 80s if I'm in my 80s, and they won't want to do any of that kind of work. So that's I'm trying to find a younger lawyer type of thing. I'll just have to search it at the time and find a younger lawyer, somebody's going to handle my estate. Is that what you're saying?
Yeah, well, you need to appoint a younger trustee. Okay, most people, when they do their estate plans in their 50s or 60s, they might appoint their brothers and sisters because they're in their 50s and 60s as well. Now, when you graduate to the next level and you're in your 70s, 80s, 90s, you need to go back and revisit that trust and change the trustees, because if the people that you've named as trustees are in their 80s or 90s, or maybe they've died, you need to go back and revisit your estate plan periodically to make sure that those people are still the people that are appointed in the documents are still the people that you want. You know, about 40% of my work is clients coming back to me 5, 10, 15 years later saying, hey, the person that I originally appointed as trustee is no longer around, or I don't trust them anymore, or maybe they're in prison, or maybe they've got Alzheimer's. And we go through and we just update the documents by naming new people to replace the people that you originally appointed. But it's really, really important that you revisit your estate plan periodically. I'm not talking every year. That'd be great job security for the lawyers. But every 5, 10 years, sit down and reevaluate and say, hey, if something happens to us tomorrow, are these people that are in our document, are they still the right people for the job? And if not, let's call the lawyer and update the documents.
Ken, as I mentioned during the look ahead to CBS News, the president is calling on courage and wisdom. It's almost like a wing and a prayer type of situation with that.
Yeah, it'll be really interesting to see how it plays out. He's banking on these appointees of his siding in his favor, and I think he's finding out, at least over the past year or so, they're not always going to side with him. And to that end, I respect those justices who abide by the law. But it'll be very interesting to see if they at least give these cases their day in court, or whether they throw them out on standing issues. I think that's the easy out for the Supreme Court, and that is to say that there's no standing, and therefore the Texas case will be thrown out before it's even heard. It's an interesting time to be a lawyer or to be up on legal issues, because they're constantly changing, and he's really pushing the envelope. At the end of the analysis, what about his ability to pardon himself? Can he pardon himself? That's not gonna go unnoticed. A lot of legal issues that they're going to be resolved one way or the other. And it's just going to be a very interesting spectacle for those of us who are observing.
The thing is, correct me if I'm wrong, but more often than not, the Supreme Court usually blazes its own trail. It really doesn't go into partisan stuff. There have been times, but that's more of the exception rather than the rule.
Right. So, and this kind of goes back to Roe v. Wade. Roe v. Wade, that was a new trail. A lot of people think that the Supreme Court should never have even gone one way or the other on that case. They should have left it up to the states, and they went ahead and blazed their own trail. Will they do it again this time? I don't know. I think it's probably going to end up being more like the year 2000, where the Supreme Court defers to the states to take care of their own electors, and they're gonna beg off on the case and deny it.
We got a couple of minutes left. Let's get one more call with Ken Puzycki. Good morning. You're on the line with Ken.
Well, I just heard Ken say, can the president pardon himself? What's he got to pardon himself for? What? Why are all the Democrats saying that he's got to be put away for what?
Well,
look at all the whistleblowers on this election. And they had one whistleblower for the impeachment thing. You tell me how that's, and look at how far they carried that to impeachment through the House. Ridiculous.
Thank you very much for the call. Go ahead, Ken.
I agree. It's ridiculous. The short answer is, and again, it's in the form of a question: can a president pardon himself or anybody else? Look at his family members; they've not been accused of anything. Can he preemptively pardon them for things that they may be accused of after he leaves office? Really interesting stuff. I don't think there's anything there, but he's gonna try to do it. It's just a matter of seeing how the thing plays out.
Ken Puzycki is a local attorney. It's the law office of Kenneth A. Puzycki. If you wish to contact him, his phone number, well, it's on James Street. That's where the law office is. How can people get a hold of you there, Ken?
738-8800. And I need to wish my wife a very happy 27th wedding anniversary and 27 wonderful years. And I love her very much.
Excellent. We're glad we were able to provide the platform for that sentiment. And again, as we mentioned a little bit earlier, we will put a link to your webpage, which is Puzycki. Let's put it this way: go to the webpage and click on it, because if we try to spell it,
come on, Gary.
No. P-U-Z as in, or P-U-Z. YC as in common, KI.com. And that makes it simple, but still,
kind of rolls off the tongue.
Well, it does to a certain extent for some of us. But anyway, Puzycki.com is the website for the law office of Kenneth A. Puzycki. Ken, have a very blessed and safe Christmas and New Year's season. And we look forward to chatting with you again in the month of February. Thank you, Ken.
You as well. Merry Christmas.
Merry Christmas to Ken Puzycki here on 99.7 and 1450 WHTC.